Hello and welcome. This is Roger Royce with the 10,000 Startups podcast. And this week, I want to talk about something that's been on my mind for quite a while. It's what's going on in Delaware case law recently with regarding startup disputes. And we have some lessons from some recent Delaware cases on startup disputes, which are common. And as you know, if you've been watching this podcast, there are various kinds of disputes that can arise in a startup. For example, founder versus founder is pretty common. Founder versus investor is pretty common. So I just want to, for a few minutes, address where those disputes typically come from, how they actually unfold in practice, what we do about them when it happens, and what a handful of recent Delaware cases and statutory developments, by the way, should mean for how you structure your company up front to deal with these disputes if and when they happen. So, first of all, a dispute itself is not really a legal issue, it's more of a relationship issue. And it could be from a change in vision, it could be a perception that there's imbalance in the amount of effort that the parties are putting in, real or imagined. Or it might be just governance dynamics. I often tell people that if you have three founders in your company, you eventually are going to get to a two versus one scenario. That happens very often, and you have to be prepared for that. And especially when you get an independent director, say you get two founders, but now you have an independent director or investor, they might team up with one founder against the other founder. So then it becomes a dispute over control, not really ideology or anything else. The second kind of dispute, the way this comes up, it's different but equally common, and that's investor versus founder. And that could be issues over performance. It could be differences of opinion on strategy and vision and where the company should go and what it should do. Or I have seen this happen. It might just be fund pressure. The investor's just ready to exit, especially with VCs who are getting towards the end of their fund and they don't want zombie companies on their balance sheet. They really want to just exit, get it over with, either take the loss or the gain. Uh, and be done with it. And I have seen companies get pushed into selling at the worst possible time because of this one. So that's another type of dispute because obviously the founders who have everything they own wrapped up in their company, they would rather not sell at the worst possible time. Now, how do these typically play out? So let's go back to founder versus founder. So here's how it'll come up. Founder A will say, hey, look, founder B, we'll call him the slacker founder. Slacker founder, you're really not pulling your weight. You either have to leave or not, but either way, you need to return some or all of your shares, even your vested shares, even though you've already earned them because you've been here long enough. Now, if founder A controls the board, then that's a tremendous amount of leverage, especially if there's typical vesting restrictions in place. Because founder A can go to the board and they can terminate the slacker founder and they can take back, cancel all the unvested shares. And very often these days, we're seeing clawbacks pop up in agreements that provide for the potential that a founder can be kicked out and lose not only their unvested shares, but be forced to sell their vested shares. And we used to call that just a buy sell agreement. Now we call it a clawback. And that is a real problem for a founder if that happens, because you're just asking for trouble sometimes. Now, the protection for the company, of course, is the 4-year vesting with a cliff, 1-year cliff. And the reason I say that is because company, you've got a year to decide whether this person should be in your company or not, right? Because it's no vesting for a year. And if you, the company, and your independent, fair-minded, reasonable board decide within a year that that founder is really not, or not even a founder, any service provider is not right for your company, they can be terminated and they lose all of their shares because they're all invested at very little cost. So that's the board control that can enforce it. And that's the typical way we do it. On the founder side, let's say that you're in a position where you're worried that might happen. You can do a couple of things. Number one, you can negotiate for some accelerated vesting, either on signing, so you vest monthly, we'll say, or you have immediate vesting on signing, or you have what they call a single trigger acceleration. That's going to be good for you, probably not so good for the company because it's out of market. So you have to be careful about what you ask for. Be careful what you ask for. But one of the worst things in a startup is getting what you want. Now, so that's kind of the pressure and the give and take on the founder versus founder scenario. Now, investor versus founder scenario. Suppose we have an investor now that's unhappy with a founder for all the reasons I mentioned. What are the typical ways that they're going to deal with it? So investors will have negotiated in a priced round anyway, sale of preferred stock, and maybe even in a side letter to a safe, actually. They may have negotiated drag along rights or redemption rights. Now, drag along right basically allows some group of shareholders to force a sale of the company. And they find a buyer who's willing to take everything, and you, if they drag you, you have to go along with that sale. So they have a way to get out. It effectively the way I've seen it play out is it's not just any one investor, it's going to be a majority of the shareholders that take a recalcitrant shareholder along with them. And as a practical matter, what it is, it's a waiver of appraisal and dissenters' rights, which we have talked about in other sessions. But just understand that such a right exists. Secondly, and maybe more effective, far more effective, is a redemption right. That means that if the company hasn't exited within a certain amount of time after the investors come in, they can force the company, they can put their shares to the company, they can force the company to repurchase their shares. You don't see that very often anymore, once in a while, but not very often because it is so punitive. But when it does exist, think about what's going to happen. The investor's going to say, I've had enough. Company, buy my shares. I'm exercising my redemption right. And the company will say, with what? We have no money, And the investor will say, well, I guess you have to sell the company then, or I'll take it. And that's how you force a sale, because companies don't have the cash to buy out investors. And that's not a good deal for anybody. That's not going to be a good sale. If you can't get management to be pretty enthusiastic about a sale, good luck. But it's just the existence of the rights that creates the leverage that can drive an outcome. Now, I said there were some recent developments in Delaware law. So what am I talking about? And almost every company I form is governed by Delaware law. Almost, not always, but almost. So here, first one is a company called Moelis, if I'm pronouncing that right. And in that company, the founder negotiated significant contractual control rights. He had vetoes over major actions, influence over board composition, control of the committee makeup. And the Delaware court initially said, the Court of Chancery said that those provisions violated Delaware law because they constrained the board's authority. And the board has fiduciary duties. You can't contract out of your fiduciary duties. But the Delaware Supreme Court reversed and said, yeah, that's problematic, but they're only voidable, not void. And plus, there was a timing issue in the case, but that's less significant for our purposes. The takeaways for the founders here is that you can have a shareholders agreement. You can contract for significant governance rights. But just keep in mind, there's some tension there, the board authority. And then subsidiary issues are, if there's going to be challenge to that, it should be done early, not later, you lose your rights. And as you know from my prior presentations, that case actually triggered some legislative action. Well, let's talk about that. What was the legislative action? Well, Delaware responded with Section 122, paren 18, which effectively validates stockholder agreements that include governance style provisions, freedom of contract, that's Delaware, and some amendments to Section 144 that created safe harbors for transactions involving controllers. So there's a tighter procedure now for approval of a controller transaction and an independent director or a disinterested set of stockholders. So what does that mean? In practice, it means that Delaware is still the king. There's more flexibility now in how you slice up the economic and control rights of company. There are structured safeguards. You can probably expect more reliance on these stockholder agreements, and of course, more importance of process, meaning independent committees, disinterested votes, etc. Second case, Massimo. Uh, this dispute is very familiar. The founder CEO lost control, and then the board changed, and that will happen. In fact, according to Carta, that happens at Series A these days. I used to say you keep control after Series A, but Series B is the new Series A. The new first place round is going to be seed or even pre-seed. So founder lost control. He claims some severance and equity benefits as a result of that. And the company counterclaimed and said, well, you breached your fiduciary duties. The issue became procedural because the contract required disputes to be litigated outside Delaware. Um, and the court held, and under the Delaware General Corporation Law 122.18, that forum selection clauses are enforceable even for internal governance disputes. So now we can contractually export those disputes outside of Delaware, which sort of makes sense because it's pretty rare. I don't think I have any clients that are actually sitting in Delaware, even though almost all of them are incorporated under Delaware law. So that's a major shift in how those cases get litigated. So the practical implications here for founders, just keep in mind vesting is super important. It's real leverage for the company. The acceleration provisions are leverage for the founder. Board control is going to determine your outcome a lot of times, not just your equity ownership. That's not nearly as important as board control, especially if you have a stockholder agreement, which is going to matter now more than ever. For investors, you have tools. Keep in mind, you've got contractual rights. You can negotiate all this stuff up front, drag alongs, redemption rights, governance rights, protective provisions, and even some other exit mechanisms. But your outcome is going to depend on asserting your rights promptly. It's going to depend on having a good process and aligning with our statutory safe harbors. And for both founders and investors, I would say that Delaware is just moving towards, Delaware is still like I say, a freedom of contract state. And this is a sign that the legislature, at least, is moving away from the court cases and towards greater contractual flexibility, provided there are procedural safeguards and some pretty clear boundaries. So in closing, I would say that startup disputes are not edge cases, they're predictable. And we have Delaware law that says the outcome is usually predetermined by the documents. Super important for a lawyer, and oftentimes shaped by how early you act, how carefully the governance structure has been put in place, and whether you build the right protections into the documents for founders and investors. We really have to strategize and what if this thing and whiteboard it and get the Excel spreadsheets out and just say, what if this, what if that, what if that, where am I, where is the company, where is the investor? This is Roger Royce with 10,000 Startups. Thanks for listening.